in the late 1980s. Remember, this thing, the drafting was done for the most part by the early 50s, and there were some changes during the 50s. It was adopted in most of the states, between 62 and 67. So we're talking about something that's almost been enacted almost 50 years, and was really drafted in a different era in terms of business practices and the like. So there was a long campaign to revise it. Not every article was revised, but most were. The last two to be revised were Articles 1 and 7, and I think I may have mentioned this last time. Every state, plus the District of Columbia, plus the United States Virgin Islands, has adopted Articles 1 and 7 now, and the only outlier is the state of Missouri. And it looks like they're going to adopt it this time. Everything is set to go. So it will be the culmination of a 30-year modernization project. And so it's kind of a red letter day for the sponsors of the code, the ULC, and the Uniform Law Commission, and the American Law Institute. And so it was kind of interesting. I got dragged around to various offices and sat down and told people, yes, you should adopt this. No, you don't need to read it. Yes, it's just fine. No, you don't want to read it. 49 other states have adopted it, and not a single person has testified against it anywhere in the United States. That was good. The second thing I wanted to announce, I think some announcements have been going out to the student body, and so some of you are aware of this. But Charlotte Koo and I have a friend, a very good friend, coming down next week to visit the law school, and he is just a phenomenal person. His name is David Stewart. David had a very long career in the State Department, and within the State Department, the person who is the principal legal counsel to the secretary is called the legal advisor, and that's who now John Kerry would turn to. But most departments within within state have their own assistant legal advisor, and the assistant legal advisor in many of the departments manages the departments. So David has been involved in human rights, security, cybersecurity, many other portfolios. I think he handled the Africa desk for a while for state. We're talking about a very, very long and distinguished career. And at one point, what brought David and me together was he was the assistant legal advisor for private international law. This was at a time. I want to take a few minutes on this. Might be worth it. This was at a time when the State Department was negotiating, or had negotiated, a number of conventions that, if adopted, would preempt state law, and some of them would have preempted parts of the Uniform Commercial Code. For example, there is an international, UN Commission on International Trade Law Convention on international assignment of receivables, and we talked about assigning as collateral rights to payment. And I also mentioned to you that Article 9 governs the outright sale of rights to payment, but told you not to worry about it. We set that aside for the time being, and made it permanently because it's at a different level of complexity. And it's really for an advanced course. But the international sale of rights to payments of money, that is the sale of, I should say it a different way, the sale of rights to payment of money where the parties to the original transaction are in different countries is an enormous flow of money around the globe. And so the UN Assignment of Receivables Convention will have a very profound effect if it goes into effect in the United States. Historically, the U.S. has not adopted many private international law conventions. specific opposition from any particular quarter, but there's a recognition in the Senate that to the extent that you adopt something that is historically state law, that you're interfering in the states, and the Senate historically has sort of backed away from doing that because they haven't felt comfortable with the consequences. So historically, the Uniform Law Commission has really stayed hands-off. We haven't tried to stop these things, even though they would preempt our acts in some instances, nor have were we historically helpful to the State Department for precisely the same reason they would preempt our acts, so we sort of stayed on the sideline. But you really can't continue to do that. And during the time I was executive director, within the ULC, we came to the conclusion that some of these conventions were really good for the United States, but we needed to make sure that they fit within the framework of state law. So how could we create that framework? And Dave was head of the Office of Private International Law at the time, and I don't want to claim credit for this. I can claim part credit because I was involved, but a lot of people were involved. We worked out sort of it's not a partnership. We have very different agendas. State has its agenda, the Uniform Law Commission has its agenda. But if there is a convention that is good for the United States, and if it is not too disruptive of state law, then there's no particular reason why the ULC shouldn't be supportive. So on the assignment of receivables, just to use that as an example, the State Department asked us to study it in depth, and we put together a committee. We pulled in people from the American Law Institute because it involved the UCC, and we spent a year studying the Receivables Convention. At the end of the day, we had worked out about 30 scenarios in which it could apply, and only one or two of those gave anyone any heartburn at all. So we asked Citibank if we could use their conference center at their headquarters in New York. They gave us permission to do that. We invited people from around the United States. We put a couple of hundred top bankers in the room. We ran over all the scenarios, and everyone at the end, I'm not sure literally everyone, but I don't remember any naysayers. At the end of the day said, no, this is good for us. Even though there's a slight dislocation with the UCC, this is good for the United States. So then the State Department asked us to continue working, and when the U.S. adopts a convention, there are various places where the Senate, in giving its advice and consent to the President, can say, well, this is how we understand this will operate, if there's any wiggle room. And interpretation, sometimes there have to be interpretations of language within the convention. So you can say, this is how this term will be interpreted in the United States. So we drafted a set of interpretations and understandings, and those went back to the State Department. David was long gone by then. The State Department did what it normally does. It sat on it for a decade. But it came out of mothballs at the urging, really, of the commercial interests. It came out of mothballs. Actually, they didn't sit on it for 10 years. I exaggerated. They sat on it for 8 years. It came out of mothballs. I was roped into being part of a team that drafted a long transmittal letter. And the transmittal letter was the transmittal letter from the White House to the Senate Foreign Relations Committee, explaining why they thought this would be good for the United States. If you're interested, I can give you a link to it. About less than a year ago, it was transmitted to the White House for the White House to look it over and see if they really wanted to send it to the Senate. Within the last 2 weeks, it was sent to the Senate for its advice and consent. Our understanding is that despite the fact that it's an election year and the Senate probably couldn't name a post office, pass a bill to name a post office, that this is bipartisan. There's no issue here, and we even have a chance of getting this done this year. So that's a long story. I thought it might be an interesting story for you, and I'm just off the airplane. I really don't want to teach Article 9 anymore than you want to learn it tonight. So, but David will be here, and he's going to on next Wednesday afternoon at 3:30. he is going to, under the sponsorship of the placement office, hold a 1-hour presentation for students. And I know some of you can't make it because you have jobs, but he's going to hold a 1-hour presentation about government, jobs in government practice and in the private world in the international sector. And he's done this before. He did it for me at Alabama a couple of years ago. It's very interesting. You get something out of it. And then on Thursday at noon, we're going to have a panel discussion. And David and I are going to be the panelists. The topic is going to be this topic of holding law. We'll talk about 8 projects of this sort because we have about 8 projects of this sort. And we'll be the panelists. Charlotte Koo will be the moderator, and food will be served for anyone who comes. I think food will be there at 3:30 on Wednesday, but I'm not sure because it's already shop, and I don't think the rules. Okay. So I wanted to advertise this thing because David now, after retirement, is now a professor at Georgetown. He is director of their global transnational clinic, global externships. He was selected by the American Law Institute as one of the reporters for the restatement 4th of the Law of Foreign Relations. I mean, we are talking about somebody who is really phenomenal and as nice a person as you would ever meet in your lives. Except he tells corny jokes, and if he does that, you won't run. All right? So there's my advertisement. So I want you all to get used to a chart like this. I've done this before, and you know that the line is just a timeline. Okay, so if I have a slash mark to the left, I've got an event to the left, and then a slash mark is the next event. And just set this up and in your notes, and then we're gonna do all kinds of things with this. Okay, but secured party takes a security interest in something. I could care less what it is, some collateral. Attachment occurs, and the secured party files a financing statement. And so the secured party is all alone. Nobody else is in competition. The secured party is properly perfected. The financing statement is good for 5 years. We know that if you file a continuation statement during the 6-month window at the end, you would get another 5 years. But our secured party does not do that, and lapse occurs. Okay? And one of the things I want to stress to you is not to jump too many steps at one time. Okay? For example, and I want to illustrate why it's important not to jump through too many hoops at once. If I were to say that after lapse out here, another secured party came along, and I'm not going to put SP1 over there, but I will. We know that's SP1. I don't want to put the 1 there because then I'd be erasing it and putting it back and erasing and putting it back as I change examples. So that's the first secured party. SP2 comes along. We have attachment here, and SP2 perfects by filing. Okay. Whoops. We'll leave this one. I'm not going to tell you whether SP2 perfected or not. I'm going to leave that as a blank. Now, the question you should ask is, in a priority contest between SP1 and SP2, is SP1 perfected? And the answer to that is clearly no, right? Lapse means you're not perfected any longer. Who has priority as between SP1 and SP2? Well, you don't have enough information. You can't answer that question. What do you need to know? What if SP2 did not perfect? Who would have priority? SP1. 2 unperfected secured parties first to attach. Remember that rule? The only rules I'm going to give you tonight go back to the basic priority rules that I gave you previously, and I said we'd be circling back again and again. Okay? So, if in fact SP2 files out here somewhere, then SP2 is going to win the priority contest. Probably. What if SP1 allows lapse to occur, but then SP1 files a new initial financing statement here. Now it doesn't matter whether SP2 files or not, does it? Because SP1 has priority. Does everyone see that and see why? It would have been better if you had caught it, right? Then you wouldn't even have to worry about it. If you caught it and filed a continuation statement, you would have been perfected right on beyond SP2 and you clearly would have won. You made a mistake. What if SP1 catches it and says, oh shoot, I let it lapse, I better file a continuation statement, and instead of a new financing statement, SP1 files a continuation statement here. Might as well not have, you wasted your breath, wasted your time, no legal effect, right? Just to illustrate a point, SP2 files here. SP1 eventually figures it out, and I'll now use SP1, and comes along and files out here, all right? I mean, it's clear that SP2 wins this, isn't it? Right? You let lapse occur, you were unperfected here. But if the rule is literally first to file or perfect, and we don't have any language other than first to file or perfect, SP1 was the first to file or perfect, right? The first to file or perfect rule is in 9322A1. Look at it and tell me what language in 9322A1 lets me ignore the fact that SP1 was the first to file or perfect and only give SP1 credit from the time of the refiling. It's in 9322A1, and I want you all to find the language. Got any takers?
If there is no period thereafter where there is neither filing nor perfection, when they're talking about the dating of filing.
Right. First to file or perfect, as long as your filing doesn't lapse and or your perfection is continuous. If there is a gap period, if there is a gap in which there is neither filing nor perfection, which is what we have after lapse, you can't jump back across the gap and start over. So it's the rule is still first to file or perfect. But if I can't give SP1 credit for this filing, who is the first to file or perfect? It's now SP2, right? With me? And just to make sure you're with me on this, SP1 realizes the day before lapse that lapse is about to occur, doesn't know what to do. SP1 is a business person. The lawyer is on vacation and can't be reached, even by satellite phone. And so SP1 runs down to the debtor and says, I don't know, I heard this somewhere. Just let me hang on to this for a while, and takes possession of it, okay? So you get possession. I'm going to use this so many times, I don't want to put too many marks on it. But you get possession right here, okay? And then you hold possession all the way out to here, and when you finally get around to refiling, you give it back to the debtor. Turn it back over. Who has priority? SP1. Who is the first to file or perfect? SP1. Does that clause at the end, if there is no period thereafter where there is neither filing nor perfection, that wasn't triggered, was it? There's no period in which there was neither filing nor perfection. There is a period in which there was no filing, but there's not a time when there's not perfection. And you can tack different periods of perfection. You can tack perfection accomplished in different ways together, so long as you never let lapse occur. Now, I think of these as sort of warm-up exercises where we're stretching a little bit before we actually do anything that's complicated. You may not agree, but if you're not with me on all of what I just did, then stop me right now, okay? I want us all on the same page from the get-go today.
I have a quick question. I forgot, Adam. When you have possession, do you need to provide any notice to anybody that you have?
Perfection is notice.
No, possession.
I'm sorry?
Possession.
Do I have to provide notice that I've gotten
When
possession?
you have the
No. The taking of possession provides notice to the world. In other words, you take possession here, okay? And later the debtor goes out to secured party number 2, says, hey, I'd like to take a loan against this stuff of mine. And SP2 says, well, where is it? Well, somebody else is holding it. SP2 isn't going to make that loan. The fact of possession is deemed to be notification. In fact, the fact of possession is better notification than a filing. Because in the natural course of things, you'll say, if I'm going to loan money against it, where is it? In order to find the filing, you have to go check the records, right? So again, all pretty simple stuff. Let's do another simple one. Instead of SP2 out here, lapse has occurred, and the debtor sells the asset to X, who takes delivery of it. All right? Is the secured party perfected or unperfected in a priority contest with a buyer? With that buyer, unperfected, right? Can you tell me whether the buyer wins or loses the priority contest? I would say you can't because I don't think you have enough facts. I have an unperfected secured party versus a buyer. How could the buyer still lose? What's the priority rule of secured party versus ordinary buyer? Regular old, not buyer in the ordinary course of business. The only way buyer can win is if it gives value and takes delivery before perfection, which it did, there's no perfection, and without knowledge, right? Without knowledge. So you can't work, you can tell me quickly, you can tell me at a glance in the priority contest secured party's unperfected. You can't tell me at a glance who wins the priority contest. You need to know whether X had knowledge of the security interest at the later of the time it gave value or took delivery. And again, all I'm doing is I'm using this lapse to reinforce the priority rules that I gave you previously. And here's the easiest of all priority rules. Debtor files for bankruptcy. I'll just put B/R for bankruptcy. Debtor files a petition in bankruptcy. Who is my adversary to the secured party? What the Article 9 term for the adversary? It's a lien creditor. And what's the rule for secured party versus lien creditor? It's the easiest of all the priority rules. Perfected, you win, unperfected, you lose. Knowledge doesn't matter. First to file or perfect rule is only between two secured parties. Never try to. Buyers and lien creditors don't file or perfect. So you wouldn't think in those terms. So the lien creditor will knock out the security interest. Okay? Have priority in this situation. So all well and good. That's easy enough. Now I've set up a series of problems here, but rather than put dates and the like, they'll all fit within this structure. I think this is 3.1.10 and this is 3.1.15, and various events occur in the upcoming problems. In the first of the upcoming problems, let's assume that during the 5 years, somewhere in here, this is where SP2 came along, okay? Not after lapse. SP2 came along back here. And it got attachment with regard to the same assets, and I'll just tell you that it files a financing statement. And then SP1 allows lapse to occur. In a priority contest between SP1 and SP2, is SP1 perfected or not? And the way that will play out is we'll get down into the future somewhere, all right? And the debtor, let's say the debtor defaults to both of them and they're fighting, and we have to look backwards from the time of the fight, and the fight occurs after lapse, so that we know that lapse has occurred. The battle occurs out here somewhere. And I just want to know, is secured party 1 perfected or unperfected in that priority contest? I don't want to know who wins it yet. In other words, never go directly to the answer of who wins the priority contest. First, answer the question of whether the secured party is perfected or not. And what's the answer to that?
When SB2 files or after the lapse?
Secured party number 1 is clearly perfected when SP2 files.
Right.
If they got into a battle here, and a court had to make a decision here, it would be SP1 would win, right? No question about that. So we're asking what happens if the court is deciding it. There's litigation out here between the two of them, and the court is looking back and knows that lapse occurred. And the question is, are we going to give the secured party credit for having been perfected here, or are we going to retroactively invalidate the secured party's perfection? And I think it's 9515C. I might be off by one. I'm not off on the 9515. It might not be C. Yeah, it is C. So what's the answer to the question? Find it within C.
Would it still be SP1 because it says it becomes unperfected and it is deemed never to have been perfected, but only as against a purchaser.
Okay. It becomes unperfected is looking forward, right? And that's easy. It's unperfected going forward. But looking backwards, it says it is deemed never to have been perfected as against a purchaser for value. So now you have to ask whether SP2 is a purchaser for value, right? Because if SP2 is a purchaser for value, we pretend that SP1 never perfected. If SP2 is not a purchaser for value, well, the secured party gets the benefit. There's no retroactive invalidation of perfection, and secured party gets credit for being perfected at the time this interest arose. Okay? And so is a secured party a purchaser? Yeah, see, it's so easy to fall into the trap. Purchaser means anybody who acquires any interest in collateral in a voluntary transaction. A secured party is a purchaser. Secured party is a purchaser for value because it gave a loan, otherwise it wouldn't have a security interest out here, right? In fact, isn't giving value one of the conditions to attachment? Secured party must give value. So if secured party 2 has a security interest, it is a purchaser, and by definition, to have a security interest, it has to have given value. So now the answer is secured party number 1 is deemed never to have filed. We just get rid of that, right? You failed to file a continuation statement. It was within your control to do it. You failed to do it. The consequence is not just that you become unperfected going forward. The consequence is that you might become unperfected going backwards. So who wins this priority contest out here at the litigation stage? SP2? You're 100% sure.
Or
Well, SP2 is the first to file or perfect, right? The minute lapse occurs here, SP2 became the first to file or perfect. We all agree on that, right? Let me give you a hint. I didn't tell you how long the time period was here, and I didn't intend to draw that to scale. So what if the litigation occurs out here? Who wins the priority contest?
So now,
are they still perfected? Or has
That's the question. What if secured party 2 allowed lapse to occur? Secured party 1 allowed lapse to occur. What if secured party 2 lapses here and neither of them reperfects. Then by the time I get to the fight, I've got two unperfected secured parties, right? First to attach wins. And what if both of them lapse, but SP2 picks up on the fact and files a new financing statement here? SP2. It wins again, right? A little more vigorous exercise. This is called the retroactive invalidation rule. Now, I'm going to explain why there is a retroactive invalidation rule without really going into it. Without that rule, I can have a three-way priority contest where my parties are SP1, and then the other two parties can be anybody. But most often there's SP1, SP2, and a lien creditor, typically a bankruptcy trustee. And if I don't have that retroactive invalidation rule, I can wind up with a situation where SP1, I can wind up with a situation where SP2 beats SP1, SP1 beats the lien creditor, and the lien creditor beats SP2. Round you go. It's called a circular priority. I will not give you one on the final exam, although I really don't mean this way. Once you know these rules, it is child's play to create one. The retroactive invalidation rule prevents that from occurring except in the strangest of circumstances. So what's the policy rationale for the retroactive invalidation rule? To prevent circular priorities. But how does it function? It functions very easily. If the party you're fighting back here, if the fight occurs after lapse, and the party you're battling had an interest that arose before lapse, and that party is a purchaser for value, this filing is deemed never to have occurred. All right? So, what if the debtor sells the asset to X, who takes delivery of it? If lapse never occurs, who has priority? See, I'm trying to make you do these exercises. I'm trying to make you do these priority contests again. Secured party versus regular old buyer. Secured party wins unless buyer gives value and takes delivery without knowledge of the security interest and before it is perfected. So if lapse never occurs, if there's continuation statements filed and eventually the secured party figures out where the collateral is, the secured party has priority, right? Perfected secured party beats an ordinary buyer. I do not want to use buyer in ordinary course of business because they have special powers and wear a cape and fly through the air and all kinds of stuff. So lapse occurs and the secured party does not do anything about it. And out here, the secured party finds out where its collateral is. The debtor defaults to the secured party. Secured party finds good old X and wants to repossess from X. And X says, no. In a priority contest, I beat you. And the secured party says, no. In the priority contest, I beat you, and you guys work it out. In that priority contest, will the secured party be treated as a perfected secured party or an unperfected secured party? It was perfected when X bought. When lapse occurred, what was the retroactive effect? Was it invalidated, this filing? Am I going to give secured party credit for it, in which case it wins? Or am I going to take this away from the secured party? What does that turn on? Sorry?
A purchaser of the collateral
question is B, I'm a buyer, X, B buyer X, confused myself. Is X a purchaser for value? What's your answer to that? Sure. A buyer is a type of purchaser. A secured party is a type of purchaser. A purchaser is anyone who acquires an interest in property in a voluntary transaction, right? So the secured party is unperfected now. In other words, you let lapse occur, you lost the benefit of the filing. Retroactive invalidation against a purchaser for value. Who wins the priority contest now? I've got an unperfected secured party versus a regular buyer. Who wins? The correct answer is you don't have enough information. What do you need to know? Did X have knowledge at the time it gave value and took delivery, right? Again, all I'm doing is applying the priority rules. Same priority rules we went through a couple of weeks ago. You all have to, what I would suggest is that you all put all kinds of charts like this and change the order of events. Have secured parties before lapse, secured parties after lapse, lien creditors before, lien creditors after, buyers before, buyers after. Work through all the permutations. That's the best preparation I can give you for the kind of questions you'll see on the final exam in this area. Okay? So now, there's not a secured party, there's not a buyer. Secured party had filed, and the debtor files a petition in bankruptcy right here. And so I have a lien creditor here. Lapse occurs, and the bankruptcy court out here somewhere, probably not that far out, the bankruptcy court has to decide whether to honor the security interest in bankruptcy or to throw it out. And just as a clue for what's coming later in the semester, if you honor the security interest, the secured party will get a distribution of value from the bankruptcy estate equal to 100% of the value of the collateral. You're 100% protected. If you have a valid security interest, if the bankruptcy trustee knocks out your security interest, you will share pro rata with the lowest of the low in bankruptcy, and just for working purposes, we'll assume you would get 10 cents on the dollar as a bankruptcy distribution, and then have the rest of your debt discharged, so you couldn't come after the debtor after bankruptcy. So it's the difference between getting 100% and 10%, and I only use 10% because it's easy to calculate. The true result in the real world is more like 3% or 4% or something like that. But all you need to know right now is the secured party perfected or unperfected in a fight with the bankruptcy trustee? They're perfected. They get credit for this filing. And how do you know that? Lien creditor. Remember I said the bankruptcy, Article 9 is written to beat the bankruptcy trustee about the head every which way from Sunday. Retroactive invalidation does not apply when you have a non-purchaser. And just for fun, truly just for fun, right here, the gives, it's a gift, the collateral to Z, whoever Z may be. Just a gift. Let's assume Z's innocent. Let's assume Z's in good faith. Let's assume Z doesn't have any knowledge of a security interest. And the secured party allows lapse to occur. Priority contest against Z, I guess this will be World War Z, is the secured party perfected or unperfected? Yeah, sure, it's perfected. But is Donnie Z a purchaser? No?
They're a purchaser, but not for.
Yeah, they're a purchaser, but not for value. It's the odd definition of purchaser as meaning anyone who got a property interest in a voluntary transaction. See, there are no rules in Article 9 that will protect a donee. The donee loses. In fact, if I were to say the secured party was unperfected and never perfected, and so we never would have lapse because you never perfected, you'd still be the donee. There's The basic rule of 9315 was a security interest continues in collateral, notwithstanding sale, lease, license, exchange, or other disposition. A gift is a disposition, unless there's a rule in Article 9 to the contrary. There are no rules that protect donees. They haven't given any value, they have nothing at stake, and therefore they will always lose. But I just thought I'd play with it to let you see that we do this time have a purchaser, but not for value. Wasn't that fun? So any questions? So just for fun, let's say D sells to X. Let's go back to that one. And let's now assume X does not have knowledge of the security interest, which would people don't buy assets with knowledge of the security interest because they know they're buying trouble, okay? So we will assume that X is without knowledge. So our secured party has filed. X should have checked the filing. X is in second place, no question about it. But the secured party allows lapse to occur. And then realizing that lapse has occurred, it files a new financing statement. Doesn't try to do a continuation statement out here. And then later we have the court battle between the secured party and X. Go back to 9317. Now, I think we'll all agree that when lapse occurred, there was retroactive invalidation, right? So the thing that we know is we can't give credit to this filing, can we? This filing is gone because I have a purchaser for value in here. So this filing is gone. 9317B says that a buyer of goods takes free, that's the language I want to focus you on, takes free of a security interest if the buyer gives value and takes delivery without knowledge of the security interest and before it is perfected. Did the buyer give value and take delivery, given that it was without knowledge, I'm giving you that, before it was perfected? Yes, because secured party can only rely on that filing out there. And therefore, what the rule says is that X takes free. In other words, the security interest is smashed when lapse occurs. If I have a buyer that wins the priority contest, and I can't revive it by a filing out there. If I had made this a secured party, this new filing might or might not work. It would depend on whether this secured party's filing lapsed. Remember we did that? But that's because I can have two secured parties with security interests in the same collateral at the same time. They can coexist, one having priority over another. In other words, if SP1 beats 2 and SP1 is owed $50,000 and SP2 is owed $100,000, and the collaterals will sells at foreclosure for $70,000, but SP1 has priority over SP2, they can coexist. SP1 gets the first $50,000 because it has priority. There's still $20,000 of value that can go over to SP2, who's then out 80. Okay, so I don't have a takes-free rule between two secured parties. I just continue to work out the priority contest between them. But if I have a buyer, then the rule says that if the buyer gives value and takes delivery without knowledge of the security interest and before it is perfected, it takes free of the security interest. and there is nothing you could later do to reinstate it. Again, each and every one of these is no more than an application of the basic priority rules, now reading them a little bit more closely. Had enough?
In the illustration on the board, is SP1 still SP1, and the second, the one that took the security interest in the middle before last occurred, SP2?
Yeah. So this would be SP2, and let's assume it gets an attached security interest and files it. SP1 has priority over SP2 as long as this filing is alive, because it's first to file or perfect. But if it allows lapse to occur, boom, that one's gone, because that is a purchaser for value. So now, if I've got a fight out here, it looks like SP2 wins because it's now the first to file or perfect. But I can't know that for sure. Its 5 years could be up here, and it could have lapsed here, right? And so then SP1 goes back in and files, and then SP2 goes back in and files. So I just have to work out the priority contest. If they both lapsed and neither is perfected, first to attach wins. If they both lapsed and neither is perfected, and then either or both of them refile to perfect their security interest, we go back to first to file or perfect. So if SP1 filed first out here, it would win. If they both lapsed but SP2 filed before SP1, it would win. All I'm doing is playing out over and over again. It's like Groundhog Day, right? Playing out over and over again the same priority contest. But at any given point of time, I'm asking myself, who was the first to file or perfect? And if they're both unperfected, then it's the first to attach. And if one is perfected and one is unperfected, the perfected one wins. All right. I know this is complicated, and so your incentive is that there will be a couple of questions on the final exam, and I mean more than one, that will use the scenario I just gave you in calling you to resolve it. Okay? So it will be worth your while. I like giving incentives to learn complicated rules. It will be worth your while to learn these rules. I'll make sure it is. Okay. We have covered problems 6, 7, and 8. Okay? And we've more than covered them. We've covered more scenarios than are given in 6, 7, and 8. But your answers are all in the analysis we just did. So problem 9. Secured party takes a security interest in a tractor. I know I use a tractor a lot. It sort of stands for a single item, okay? And it has to be a single item as to which you would perfect by filing, and you don't perfect by filing as to cars because there's a different method. You use the certificate of title as the notification method, which we'll get to much later. We haven't talked about that. I think I mentioned it in passing once. So, you know, it could be a bicycle. It could be virtually any single asset. I'm not focused on farm stuff, but so secured party has a security interest in a single item, in this case, a tractor. And it files a financing statement in, of course, the debtor's name. That's the key, right? Because searchers are going to search under the debtor's name. So now we rock along, and a few months later, B changes its name. And remember, if it was an individual, the only name that counts is the name on the driver's license. So if it's an individual, we're going to assume that the driver's license was renewed with a different name. Okay? So there is a name change that has occurred. And then we go out here somewhere, and D sells to X. Okay? Now you represent X. And X says, you know, this is a pretty expensive tractor. You spend a lot of money on modern tractors with air conditioning and all kinds of stuff. So this is a top of the line. Got a couple $100,000 involved in it, and I want you, lawyer, to make sure that I'm safe. All right? X comes in, and one of the first things you'd say is, well, we better worry that there might be a security interest, right? Go check the filing system under the debtor's name, right? That's what you'd say. But the debtor's name that X knows is not the same as the name on the financing statement that the secured party filed, right? So X goes and searches the filings and reports back. Didn't find anything, nothing in the debtor's name, and you say, fine, you're safe, go ahead and buy it, no harm will become you. And then D, of course, defaults to the secured party. By the way, remember that D is the obligor and X is now the debtor with respect to this. But in a priority contest, it's just secured party versus buyer. So the obligor defaults to the secured party finds good old X and wants to take the tractor, and X is just a regular old buyer, and it's the same priority rule. The secured party wins, the security interest continues notwithstanding sale, et cetera, unless a buyer of goods gives value and takes delivery without knowledge of the security interest, and we'll assume without knowledge, and before it is perfected. And the question is, was the secured party perfected for purposes of this transaction?
How long did they?
Oh, it's either within the 5 years, or there was a continuation statement. I'm done with lapse. No financing statement will lapse again tonight. Okay? So the question is, should a name change cause you to become unperfected unless you file in the new name? Because, of course, you see the problem from X's perspective, don't you? X does the most logical search available to X and comes up dry. And it may seem sort of unfair to say, well, your filing in this person's name perfects you even though there's been a name change. Why didn't you go out and find out about the name change? Why didn't you amend your financing statement to add the new name so that people would be on notice? I mean, that's really the question, isn't it? It's a policy question, really. It's who bears the burden here. Does the secured party have to keep track of every filing it makes in the eventuality of a possible name change? Or do people who buy need to know that they need to ask, what other names have you been known by in the last X number of years, and search under all those other names, right? Because X, properly advised by the lawyer, would have gone back to D and said, what other names? Have you had any name changes? Had your driver's license changed in the last few years? And done a little more investigation. And as attorney, what mistake did I make by saying, oh, you're fine? I would never say that. I would say, from the records, it appears that there's no problem, but I cannot guarantee you that there is not somebody out there who filed under a different name and has a valid perfected security interest that will beat you. I'm not going to give a clean opinion when there is this kind of risk. Okay? And if you don't want to take that risk, don't buy the tractor or purchase insurance, kind of like title insurance, in the event this occurs. There are ways to protect yourself. Okay. But what's the rule? And we've got two easy policies. One is file and don't worry about it. Name change happens, tough for the person who searches afterwards. Or keep track of things and catch name changes and amend your filing to add the new name. Yes.
Well, I might be completely wrong, but I thought there was a rule under 9507B and C that said that even if the name is misleading, it's not rendered ineffective. But in 9507C1, it says that if it's before 4 months, and then if it's after, then it's effective. If it's after 4 months, it's ineffective. That's why I asked about the time change earlier. So it was,
You got it.
Okay.
So let's start with 95078, and this is a companion piece to 9515A1. 515A1 says a security interest, the existence of the security interest, continues notwithstanding sale, lease, or other disposition unless there's a rule to the contrary. But the baseline rule is the security interest continues. This rule is a filed financing statement remains effective with respect to collateral that is sold, exchanged, leased, licensed, or otherwise disposed of, and in which a security interest continues, even if the secured party knows of or consents to the disposition. In other words, D comes to the secured party and says, want to sell my tractor? Secured party says, go ahead, I don't care. D sells it to X. Security interest continues, and the filing continues. Now, what if the message from D to the secured party was, I want to sell free of your security interest. I want to sell, and I want to make sure that whoever buys has freedom from your security. That's different than saying, I want to sell. Because the secured party could say, sure, sell, we don't really care, but our security interest continues. Go back to, just as a placeholder, not placeholder, as a reminder, go back to 515A1. A1. The security interest continues notwithstanding sale, lease, license, or other disposition unless the secured party consents to the disposition free of the security interest, right? It's 315. I've told you and told you and told you. You are responsible for what I think, not what I say. I'm sorry. Go to 9315A1. And 9507 is a companion to 9315, not 9515. My brain was in the wrong track and couldn't get out of it. 9315A1. Security interest continues, notwithstanding the disposition, unless the secured party consents to the disposition free of the security interest. And a filed financing statement continues. This is 9507A. Notwithstanding disposition, even if the secured party consents. But if the secured party consents to the sale free of the security interest, then the security interest is gone and there's nothing to perfect. Okay? So it's one thing to know of or consent to the sale. Your security interest continues, your filing continues. If the secured party consents to the sale free of the security interest, security interest does not continue. And what is the language in 9507A that tells me I'm no longer perfected? Logically, I can no longer be perfected because I've given away my security interest and don't have it anymore, so there's nothing to perfect. But find the language in 507A. Filed financing statement remains effective with respect to collateral, that is, et cetera, disposed of, and in which a security interest continues. If the secured party agreed to the sale free of the security interest, the security interest would not continue in the collateral because 9315A1 says it would not continue in the collateral. Again, the easy rule is if the secured party says to the debtor, you can sell to somebody or give to somebody and they will take it free of my security interest. The security interest is gone forever and there's nothing to perfect. That's the simple rule. I'm squeezing it out of complicated language, but there's a simple rule underneath this. So that rule says file and forget about it, right? And that is a policy decision. The policy decision is if you file your financing statement, it continues to be effective. And you don't have to worry about things like name changes. D sells to X. X loses. The filing is still, it hasn't lapsed. X loses because the filing continued, right? Continued to be effective. X sells to Y. Is the filing effective against Y? What's the rule? 9507A. Filing remains effective notwithstanding sale, lease, license, or other disposition. Right? Remains effective. How's Y going to find out about it? Whose name is Y going to look under? Y is going to look under X's name, right? Any security interest? So Y has a savvy attorney who says, check for prior names. Turns out X has a couple prior names. You search under each one of those. Great job, but you still lose, don't you? Because you have to say, how many names did you file under, and where did you get this sucker, and I need to track it back, and I need to search under that person's name. You see the burden we're putting on searchers? Why is the policy to put that burden on searchers? What is the possible justification? And you see why you don't give clean opinions that say, oh, you're fine. There's hidden stuff. The filing system gives you a starting point if you want to ask the right questions and know the right questions to ask, and if you get honest answers. But what's the policy justification for this?
Is it to prevent debtors from kind of doing like acrobats, right, to try to hide?
I don't think so, because debtors will do those things anyway. If a debtor needs money, it will violate all the rules in the security agreement, cash out the collateral, and try to disappear or hold off the secured creditor as long as possible. So I think this rule actually has the opposite effect. It does not facilitate debtors in doing that because whoever buys it is going to take subject to the security interest, right? Because it continues perfection.
Is it to protect the secured party? Because if the debtor doesn't change his name, then
This only happens if the debtor changes name. How often does that happen in relation to the number of filings you make? Think about the number of filings that Citibank makes. I used that earlier. I don't know if it's tens of thousands or hundreds of thousands or more than that. And what percentage of those is there a name change? It's a very low percentage. And of course, the filing is good for 5 years, and the name could change on any day of the 5 years. So you're going to track the name of every debtor every day on a forward-going basis to catch a name change problem? Or the efficiencies and economics of the situation say, that is too much of a burden against that small of a risk, we're going to put the risk over there. And that's what's happened. Okay.
And you said earlier, this is going back a little bit, if the secured party had said you can sell it free, the secured interest, then it doesn't matter if it was filed or
That's
not.
right. That's right. Because if the secured party says not only can you sell it, but you can sell it free of my security interest, then under 9315, the security interest would be severed. And so there would be nothing left to perfect. So we wouldn't even have a priority contest. 9315A1 would tell us, well, I guess it would be a priority contest, but 9315A1 would tell us that X here took free of the security interest. Again, if you consent to a sale free of the security interest, you can't complain later and say, oh, whoops, wish I had my security interest because now I'm not being paid. It would just be an estoppel rule. So, are there circumstances where it would make sense put the burden back on the secured party to find a name change? The answer to this is yes, but you have to think of what those circumstances might be. This was a one-time deal. Single item, single loan. Debtor walks out the door. You're never going to see each other again as long as the payments are made. File your financing statement. Forget about the situation. Don't worry about the debtor. Why track them down? Who cares? But let's suppose that instead of a single item, I have a security interest in, as problem 10 says, SP takes and files a security interest in all equipment whenever acquired. I've used AA before. All equipment, including after acquired, of Duff's Brewery Inc. Filing occurs on 3/1/10, and I do need some dates here. Oops, that's supposed to be a 3. And somewhere down the road, again, no lapse. Somewhere down the road, Duff's Brewery changes its name, refiles articles of incorporation, and the new name is Springfield's Finest. So I've got a name change, okay? But the secured parties file a financing statement, right? And I do need a date for the name change. What did I put in here? Was it 5/10/11? And of course, lapse hasn't occurred because I'm just 1 year into the life of the financing statement. Now, let me give you a little a set of assumptions that the drafters of Article 9, and this rule goes all the way back to the 1950s, 60s. But here's an assumption that they made then that is true still today. If you are a bank of any financier, and you're taking a security interest in after acquired assets, what it means is, in all likelihood, you have an ongoing lending relationship. Okay? I'm not just worried about having enough collateral to pay back this single upfront loan, which I had when I had the single item. I'm worried about after acquired collateral because I'm likely to be making more loans in the future. I'm going to continue to finance this business. And if this business ever fails, no matter how far down the road, I want to be able to go after all the equipment that is on hand when that occurs. So again, I could, just as a precaution, take a security interest in after acquired stuff and not have an ongoing financing relation. But the assumption of the drafters was, more often than not, an after acquired property clause signals the likelihood of an ongoing financing relationship. A bank in that kind of relationship will want to send a loan officer out to the premises on a regular basis to look and make sure its collateral is still there. Okay? We're going to send a loan officer out every 3 or 4 months. And they're going to walk in with a list of the major pieces of equipment that we know were there. They won't be listed separately in the security agreement, but believe me, the lender will have a list of the stuff it's counting on. And it'll say, you got some new stuff? We need to add it to the list, after acquired stuff. We need to update our list. Has any stuff broken and it's out of commission now? And one of the reasons to go out there is if the debtor's selling the equipment off, you'll find out about it, right? Debtor's supposed to hang on to it, keep it in good shape. And then you might say, and while I'm out here, I need to make sure it's still insured because I assure you the security agreement will say that the debtor must keep it insured. We want evidence that your casualty insurance policy is up to date. And if the bank is doing follow-up contact every few months with the debtor, what other question could it ask? Has your name changed? So the assumption of the drafters was that in an ongoing lending relationship, party would make contact with the debtor every few months, and they picked 4. Okay? Maybe they could have picked 6, maybe they could have picked 8. When we looked at it again for revised Article 9, the question was put out to lenders, what is your practice? And it was still 3 or 4 months. So 4 months continued to be sound business practice in 1998 or 9 when it was being drafted to become effective in 2001, just as it was years and years earlier. Now the secured party can find out about a name change, so the rule ought to be different. Okay? And now we get down to C. 9507C, it was alluded to earlier. If the name that a filed financing statement provides for a debtor becomes insufficient as the name of the debtor, so that the financing statement becomes seriously misleading, and that's what's happened here. The name was Duff's Brewery, now it's Springfield's Finest. Anybody searching under Springfield's Finest is not going to find a financing statement that says Duff's Brewery. Then 1, the financing statement is effective to perfect a security interest in collateral acquired by the debtor before or within 4 months after the filed financing statement becomes seriously misleading, and is not effective thereafter unless you change the record to show the new name. That's I collapsed part B. Okay. So in the problem, you are told that on, I think is it 610? It doesn't really matter. 610, 11, 615, whatever. The company acquires a new forklift. Remember, it's the same company, it's just a new name. On 615, 11, they acquire a forklift. And on, what's the date? Somebody read it to me. 10/15/11. They get a cart, right? It's an electric cart. And let's assume that at the time of the name change, there were 30 other items of equipment that were already there, okay? Already on hand at the time of the name change. Question number 1, does the secured party even have a security interest in the forklift and the cart? I'm not asking is it perfected, I'm not asking does it have priority, does it have a security interest? Back to basics. Can a security agreement provide for a security interest to attach to later acquired collateral that is within the description? Yes, it does have a security interest. Is it perfected as to these 30 items that were on hand on the date of the name change? Yes, that's the rule. Rule A, Rule 9507C, C1. The financing statement is effective to perfect a security interest in collateral acquired by the debtor before or within 4 months after the filed financing statement becomes seriously misleading. Okay? Is the secured party perfected as against the forklift? Yes, it was acquired within the 4-month grace period. Why a 4-month grace period? Well, we can't expect you to catch a name change instantly. Remember the deal was you go in every 3 or 4 months, so you get 4 months. Is the secured party perfected as against the cart? The answer is no. So if I put a bankruptcy trustee out here as a lien creditor, the secured party has priority with regard to all that stuff and loses with regard to this. And what could the secured party have done to win as to the cart? Could have found out about the name change, and it could have filed an amendment to its financing statement to add the new name. And if we add the name out here, then this is before the lien creditor comes along, and you are perfected, right? But if you don't change the name, you run the risk. And we're out of time, but I want to tell you that this is absolutely a compromise. Everybody is uncomfortable with file and forget because it puts so much burden on searchers, but because of efficiencies, that's the rule, file and forget. But this is a situation that is undertaken by professionals. I mean, banks don't get into after-acquired lending unless they're supposed to know the rules of the game, and if they don't know the rules of the game, who cares? They lose. make it up in interest on the next transaction, learn the rules and do better next time. So I don't think of this as a hard rule, but it is a compromise rule. And hopefully I've fleshed it out so you can see why the compromise is made. Right? So for next time, problem 11 we've actually covered previously. It's just a reminder. Problem 12 will take us very, very little time. The next problem set 11 is easy. Perfection by possession and control is easy, and I believe it's made it easy, but it actually is easy. So you are at risk that I can go through the first 3 problems in the problem set after the next one. I'm going to end this, do all of the next